Well, my name is Jennifer Brandy, and I'm an elder law attorney. And I just first want to say thank you to Hyattsville Aging in Place, especially Loretta, Lee, Carter, and Lisa. You guys have been great in setting me up. And I'm really excited to talk to you guys. In particular, since I'm a part of the Route 1 communities, I live in Hyattsville with my husband and my 3 boys. And prior to that, we lived in Cheverly for about 10 years. And prior to that, we're from New York. So Hyattsville is now our home. I work for Stately and Salito, which is a law firm in Annapolis, and we focus on elder law. That's all we do, all issues related to elder law. And today's presentation is just we're probably gonna hit a number of topics based on the questions that people asked when they signed up. But the presentation is going to focus on preserving family assets. So I'm going to share my screen, if that's okay. Can I begin? Okay.
Yes.
Okay. Okay. So again, I'm going to talk about preserving family assets, aging with dignity, long-term care, and Medicaid planning. So just a little legal disclaimer. Everything here is just for educational, informational purposes, and it's not necessarily legal advice. And please consult an attorney with any individual questions particular to you. So what are we talking about today? We are going to talk about providing for personal care as we or our family members age, providing an opportunity to stay in our homes while receiving care, aging in place, preserving family assets, and preparing for many years of care. So who are the central players at this stage of your life? Well, of course, it's going to be the individual need, family members, but sometimes it's community members, your healthcare agent, which hopefully you have in place. That's going to be the person who will help make healthcare decisions on your behalf if you cannot. A financial power of attorney, that's going to be the person that you've chosen that will make financial decisions for you if you can't. And then there are others, such as an elder law attorney, and that's going to be someone who helps with legal issues commonly faced when getting older. It can be related to healthcare, financial, housing, long-term care, getting your estate plan in order, doing your will, and those types of related planning. You may also have a financial planner that you'd want to consult to talk about your assets. And then also really important is a geriatric care manager or social worker. This is going to be someone who can help you navigate resources and help make a plan based on your medical needs. They're a great resource. So congratulations, you've lived to a ripe age. You've had many experiences. You may have substantial assets. You may or may not have family, but you certainly have a community. And as we get older, one of the things that triggers the need for personal care is our activities of daily living. So activities of daily living are pretty much categorized as transferring, which is mobility, bathing, dressing, eating, continence, and bathroom use. So ideally, we want to age in place, right? Two of the important considerations are going to be, what are your financial resources? And what is your willingness to utilize services? It's actually really important. So for financial resources, paying for in-home care, do you have the resources to do that? And the willingness to utilize services is going to be pretty much, you can't go out this alone. You may need to have a social worker or a care manager, support groups, respite services for the caregiver, food services, grocery delivery. You might even want a grandpad, which I've heard about recently, which is like an iPad with large buttons, and you can communicate with family and do all kinds of nifty things with it. So utilizing technology too might be important. So long-term care insurance. The question is, how are we going to pay for the in-home care? One of the options is long-term care insurance if you have it. If you have it, it basically equates to private pay. So you paid into this policy, and now when you need the care, you have a couple of options of how you're going to use that policy. A caregiver can come to your home to assist with your activities of daily living, or it can pay for assisted living if that's that better option for you. And it can also pay for nursing home care. That's when you have a need for more constant care. So just an important note to make here is that long-term care insurance is its own thing. It's not Medicare, it's not Medicaid, it's not health insurance, it's not disability insurance, and it's not life insurance, but with the caveat that there are some hybrid policies. And a hybrid long-term care life insurance policy is basically where you paid into the long-term care policy, and if the benefit's not used, then it converts to a life insurance policy at your death. So here's how the long-term care insurance works. Let's say you have a $250,000 policy, and if you can average that, maybe based on your medical needs, you're going to need in-home care at about $250 per day. And at 365 days a year, that's going to work out to be a little over 2.5 years of care. So that's your insurance pool, that $250,000 policy. Now, the slower you use it, the longer it's going to last. If you use it fast, well, then it's going to last less time. So what is the cost of nursing home care? Some of you guys may have heard these figures. In the DC metro area, the average cost that we see is about $11,000 to $15,000 per month. Now, this is nursing home care. I've mentioned assisted living very quickly. That cost can really vary. It could be on the lower end at $4,000 a month or upwards, depending on where it is. So now what happens if you don't have private pay? You don't have the resources to pay for your care at home or assisted living, and perhaps there's a higher level of care needed. There is Medicaid long-term care in that instance. So it's a government program that pays for people needing a higher level of care. So just to make another note here, it's really important to understand that Medicare and Medicaid long-term care are very different. So Medicare, it pays for health care. It's basically your health insurance, and it's available to those who are 65 and older and people with disabilities. It does not pay for long-term care. The most it does is pay for the first 100 days of long-term care for each spell of illness. So without sort of going into more of that, we'll just focus that it pays 100 days. And in reality, it's not a true 100 days. It's usually about 20 or 21 days that it pays fully. And then from 21 days to the 100, there's a copay from the family. And if, in fact, if you have supplemental health care insurance, that's where it's very useful because it can help pick up that copay. The copay could be as much as $200 a day, so it can be quite costly. So Medicaid long-term care is totally separate. It's just that. It's for long-term care. You must meet medical and asset income requirements in order to qualify. Okay, so qualifying for the benefit, there are two components to it. You have to qualify medically, and you have to qualify financially. So medically, long-term care is usually for those who need a higher level of care. One of the things that is looked at is the need for hands-on assistance with 2 or more activities of daily living. These are activities you can't do on your own. You need hands-on assistance. Or maybe you need supervision of 2 or more activities of daily living and help with instrumental activities. Instrumental activities are like using your phone, shopping, laundry, meal prep, and management of your finances. So this category is usually geared towards those with a cognitive deficit. Now, for the financial piece, the person who's applying for the benefit must have assets less than $2,500 in their name. If the person is married, The spouse must have assets less than $128,640. Those numbers change each year. The 25 has been pretty steady, the 2,500, but the spousal maximum changes each year. It goes up a little bit. So I'd like to talk a little bit about the types of Medicaid long-term care. So there's two kinds that are the most frequently used. There's the home and community-based options waiver. That is the aging in place portion. The waiver is, the definition is basically you're waiving the need to be in the nursing home. You still need that level of care, but you don't want to be in the nursing home. You want to receive it at home or at assisted living. But there's a caveat to that too that I'll get to. And then of course there's the traditional nursing home. So with the waiver program, care is provided in the home by certified care workers. The state of Maryland, if you're approved for waiver services, will also retrofit your home to meet your care needs. There are limitations to that, and it also covers adult daycare. Nursing home is care that is provided in a skilled nursing facility. So those are the two programs under the Medicaid long-term care. So waiver, like I mentioned, it's the closest to aging in place, the goal that you're trying to achieve. If you qualify under waiver, you can receive home in your care. Now, the medical and the financial qualification is the same process as the nursing home care. The services at home, though, cannot cost more than services provided in the facility. So when I mentioned on the last slide that the state of Maryland will cover retrofitting your home, they do some calculations and they figure out if that's going to make financial sense for them and if it's better that the care is received in the home. Assisted living is also included, but it kind of depends. You can get approved for the waiver program, but then it's going to be up to the applicant or their family or whoever's assisting them to find assisted living in this area, which can be really challenging. There's not a lot available, and not each of them accepts people from the waiver program. Now, when you apply, you can apply if you're still at home receiving care, or you can apply from the nursing home. So, some facts about the waiver program is that there is a wait list. And this is pretty unfortunate, but the state of Maryland has roughly about 7,500 slots for the waiver program, but only funds about 3,000 per year. If you apply for the waiver program from the community, meaning you're still living at home receiving care, you can be on up to an 8-year waiting list. So that's pretty daunting. Now, I just found out recently that the state of Maryland is trying to do what's called, they call it an 80-20 triage. So what they're trying to do is make sure that 80% of available slots go to those most in need of nursing home care, and 20% will go to those longest on the wait list but still at home. So that's the recent approach to it. Actually, one of the things that we frequently see is that if you want to get accepted to the waiver program, usually the fastest way to get approved is to actually enter nursing home care, become qualified, and of course, qualify medically and financially and ask for the waiver program. And because you're already in the nursing facility, the priority then is to try and get you out and back inside of your home. So what we've seen is probably the quickest turnaround time from the time the person enters the nursing home care and applies for waiver is about 3 to 4 months. So it is a faster way of receiving the waiver services and getting back at home. So for the financial eligibility requirements of the individual, this is pretty important. And this is sort of the crux of what we do here at the firm, is looking at a client's assets and figuring out how do we get them eligible. So Medicaid is means tested, meaning the recipient must have limited financial means. That looks different for everyone. But on the day of the application, or the eligibility date, the individual who's seeking the benefit has to have less than $2,500 to their name. So there are some exceptions. Maryland Medicaid considers these exceptions: life insurance, that all of them total together have less than the $1,500 face value; personal property, burial spaces, your house with an equity limit up to $893,000, and your car. So for the waiver program, because here's the other component of Medicaid long-term care. They look at your assets, but they also look at your income, okay? So under the waiver program, your income must be under $2,300. If it is over, you will not qualify. Now, if it's under and you're approved for the program, then you actually get to keep your income, which is different from compared to if you go into the nursing home. Because if you go to a nursing home, the resident, you'll have to pay your income to the nursing home. Okay, that's considered your private pay portion on top of the Medicaid benefit. Okay, but what they do first is they take your income and they'll deduct from it any health insurance premiums, a personal needs allowance of $83 each month, and a spousal allowance, if any. And I'll get to spousal allowance in just a moment. So I'd like to talk a little bit about how Maryland Medicaid will look at your assets. Some of you may be familiar with the term 5-year look back. So basically, Maryland Medicaid will look back on your assets and review any large transfers. If it cannot be explained, a penalty might be imposed. So Maryland Medicaid is basically looking at all your bank statements for the past 5 years, your IRAs, your checking, your savings, even your stocks, and they're going to see if you made large transfers, and they're going to make the assumption that it was done for the purpose of qualifying for benefits, okay, as if you're gifting the money. That's not always the case. There's often reasons why the money might transfer, but that's how they look at it, and so we would have to explain why the money was transferred. So here I give a quick little example to show you how the look back works and how it can trigger a transfer penalty. So the example here is in January of 2018, Mary transfers her home and most of her assets to her son, Joe. It's about $300,000. In January, about 2 years later, Mary goes to a nursing home and applies for long-term care. She transferred her assets within the 5 years of application for long-term care Medicaid. So she's probably going to get a penalty if she can't explain it. So this is how Maryland Medicaid treats transfers. They take, for every $9,231 that you have given away or transferred or gifted, they treat that as 1 month of care. So in this example, $300,000 was gifted, divided by the 9,231, and Mary ends up with a 32-month penalty period. So Mary can qualify for Medicaid long-term care. She might be under $2,500. She qualifies medically, but now she's got this penalty period because of the transferred assets. And just in case you're wondering where this $9,231 comes from, that is the amount that Maryland Medicaid pays to the nursing home. That is their average that they're willing to pay. And that figure usually changes yearly, but just by a little bit. Okay, so what do we do about the well spouse? So if we're talking about a married couple, the applicant themselves, let's say it's a husband, the assets in his name have to be under $2,500. But what about the spouse? So the community spouse, or as we sometimes refer to them, the spouse in the house, is entitled to some assets and income, but they are limited. So the spouse in the house can keep a certain amount of the resident who's going to the nursing home can keep some of their income, and oftentimes they can keep all of it. There's a calculation that we do to help figure that out, and it's based on the income of both the husband and the wife. It's also based on if there's a mortgage and other household expenses. But oftentimes the spouse in the house can keep some of the income, if not all of it, and it doesn't have to necessarily go to the nursing home. Now, as for assets, the state of Maryland has a minimum that the spouse can keep $25,728, up to a maximum of $128,640. So I know I've mentioned that the assets in the one spouse's name who's applying for nursing home care has to be below $2,500. But if we back up, the state of Maryland looks at all the assets together. Okay, so it doesn't matter if some assets are titled in the husband's name and the wife's name, they have separate accounts, doesn't matter. The state of Maryland looks at it as one pool of money. Okay, so all the assets are added together, and then they're divided in half, and the spouse in the house can keep up to a maximum of $128,640 for their share. So what do you do when you're in this situation? There's a couple of things that can be done, okay? So if you're looking at long-term care and it's a married couple, and even for a single person, these apply with the exception of number 4. You pay off debts. If you have a mortgage, pay down the mortgage. You can pay down your loans. You can purchase excluded assets. You can purchase a car. You're entitled to 1 car. And if it's a married couple, you can have 2. Purchase funerals. Both for the wife and the husband. You can spend down on eligible expenses. So if you have a home, you can get a new roof, get an HVAC, do whatever you need to do to the house. And if your assets are over, if they're still over $128,640, talk to an elder law attorney. So important. There's a lot of things that we can do to help preserve assets over that amount. So I mean, in a nutshell, what we basically do is we transform those assets into an income stream. That is our goal. If we can take the asset, make it into income, then it's basically off the table. And we do that for the benefit of the spouse in the house. So in some, we basically rearrange assets so that they can become excluded. And there's a number of ways to do that. So I like this quote. You may delay, but time will not. And I felt like it was really appropriate. I know it's hard to think about, like, how do I plan? You know, no one really wants to think about these things. But if you can put some sort of plan in place now, I think it will help you. It will help your caregivers. It'll help your family. I know my presentation focuses mostly on Medicaid long-term care and that benefit. But one of the most basic things you can do now, if you don't have it, is make an estate plan, and that's 3 things. It's a will, a power of attorney for your finances, and a healthcare agent, someone who's going to help make medical decisions on your behalf when you cannot. Those are the 3 most important documents, and it's hard for me to say one's more important than the other, but one of the big ones is the financial power of attorney, because that is a document that controls during your life. Okay, you appoint an agent. The agent's going to make decisions on your behalf based on your finances, but it can go way beyond that. It can go in terms of business dealings you have, and if you own a business, and there's so much encompassed in that financial power of attorney. And we find that if one is poorly drafted, if it's taken from the internet, that can cause a lot of problems when it's actually needed. The state of Maryland has its own statutory form that we can add on to, but there has to be certain boilerplate language in it. And if it's not there, banks will not recognize it. You'll have, like, your caregiver or agent will have a really hard time. And that can lead to sort of a more cumbersome process that's called guardianship. So I would say these documents are really, really important. Will, financial power of attorney, healthcare directive. And of course, please see a lawyer who focuses in elder law, especially if you have issues that go beyond just basic estate planning. If there's a need for long-term care, if it's somewhere in the horizon, this is going to be the best person to talk to. They can help navigate what to do with your finances. How can you protect some of your assets so that the spouse is not impoverished, and even for a single person, so that some of the assets can be set aside for their benefit. There are ways to do that as well. So I just want to say thank you again. Thank you for listening to the presentation. This is my contact information. I'd be more than happy if you send me an email. If you have some question that you thought about later, if you were unclear about something, I'm happy to talk to you. And as I mentioned earlier about geriatric care managers and social workers, here are a couple of resources. Jennifer Sapp and Lynn Carr are people that we often refer our clients to. We hear nothing but good things about them. They're very helpful to family members and those who are facing like really tough medical conditions and decisions about what to do in the future. And Jennifer Sapp in particular, if you go to her website, she has some really nice, really short videos, like 5 minutes each, and gives you sort of a snapshot on the various topics. So I'd encourage you to just check it out. So that is the end of the presentation. And I'd be happy to start answering questions. I have a number of questions that came in, and I can start with those. Does that sound good, Loretta?
Yeah, that sounds great. Unless Lee, do you want to do anything at this point, or?
No, let's go ahead and start with the questions that came in earlier by email, and then there are a few questions from the chat, but we can do those.
Okay, great.
Perfect.
Wonderful. Okay, so some of the questions were overlapping with topics, so I did summarize some of them, but hopefully I'll answer what everyone was asking. Okay, long-term care insurance questions. I got a number of those. The best thing that I can tell you, and not being in that industry and not sort of knowing the ins and outs of it, is that the younger you get it, the less expensive it's going to be, and that kind of makes sense. If it's available through an employer, I think I would definitely start there. I've heard that the government is pretty good on that one. And oftentimes you can find a policy that not only covers yourself, but also your spouse. And then also check into hybrid policies. I mentioned it earlier in the presentation. It's basically when you buy the long-term care insurance, but it has that term insurance component. So if you don't use the benefit, then it converts to a life insurance policy that is payable to beneficiaries on your death. So here's another question, cost of home care. Well, that really varies. I would say that on average, like a caretaker or an aide through an agency is going to be maybe $20 to $30 per hour. There are a number of agencies that require like a 4-hour minimum. But the benefit to using an agency is that they're licensed and insured, and they can send out a substitute if the person that normally provides the care is not available. Word of mouth is always helpful. So I guess being in a community like, the Aging in Place would probably be a good place to start. I would think that maybe some folks have used it on one time or another. Okay, so I thought this was a good question too. Why should we expect someone else to pay for our care when we're older? We pay for ourselves until we become infirmed, and then we don't want to pay for food, shelter, or medical care? Well, I think the fair answer is we should expect to pay for some of our care. I mean, that's just a reality, especially if you want to age in place. You're probably going to have to have some resources in place, and in particular, if you don't have a lot of family assistance. Now, sometimes that is the advice we give our clients based on their financial situation and what assets they have. They come in here and we talk about Medicaid long-term care, but once in a while the advice is use your personal finances. And that's going to be really dependent because it's based on the healthcare needs of the individual and what it is they want, maybe how long that the life expectancy of the person if they're really ill. And so sometimes it is just better to use your own funds. But when you don't have your own funds or you have very little, then Medicaid long-term care is an available option. So the next question was how to help an aging parent. I would look at what services you can utilize first in terms of helping them to stay at home. Home care for a few hours, family rotation, make a list who can come in and out, maybe members of the community. Meal service, grocery delivery, anything to make their lives a little bit easier. Modifications to the home. And that's where I would definitely urge a family member to consult with like a geriatric care manager to make a plan. They can give you some good advice. They're like a neutral third party. They don't have an interest in you going anywhere in particular. They can just give you advice based on your situation and tell you what might work best given your situation. There was another question about whether nursing homes or assisted livings take disability income. And sure, I mean, they'll take any source of income. So when it's Medicaid long-term care, the applicant has to pay over their income, okay? Less any spousal allowance or healthcare premium, like I mentioned, but your income does have to be turned over to them. Now with assisted living, it's the same thing. I mean, you have to have a source of payment. I would think though that because assisted living can be a little expensive, that the disability income may not cover that and you would need an additional source of income. Trust. Got a lot of questions about trust, which is always a hot topic. You know, do I need a trust? Do I need one? And whether they adversely affect our taxes. So I'll give you a typical lawyer answer. It depends. It really, really depends. So whether it's going to affect your taxes is going to depend on the language of the trust. So that's a really hard question to answer in a very simple way. And then it depends on what do you want happen. What is your goal? What are you trying to do with your money? A trust is not always the right answer. It is more costly, and sometimes it is the right answer, but sometimes it is not. If it's for the purpose of trying to avoid probate, I would say, well, it depends on what your assets are. If they're pretty simple, you've got a house, you've got a couple of cars, you've got some bank accounts, a trust is probably not what you need. Probate in the state of Maryland is not difficult. It's a fairly easy and painless process. There are other kinds of trusts that we often use here in this practice related to preserving assets. I'm going to say that they're special needs trusts, but there's several kinds, and it really depends on your situation. So it's not an easy one to answer. Then we have a question about irrevocable trusts. I'm not sure how many people might be familiar with that. An irrevocable trust is a asset protection strategy that is used sometimes, but this is what winds up happening. The trust has to be written very specifically. I mean, the language has to be very, very specific, and if it's not, there's going to be problems because we had a client recently who came in and it was titled Irrevocable Trust, but when you actually read the language, it was not an irrevocable trust. So they didn't get what they paid for or bargained for, which turned out to be okay in the end, but it's not what they expected. So it has to have certain language. And here's the other thing that I would caution towards when you're thinking about this, is that when you establish an irrevocable trust, you're putting all of your, whatever assets that you put in there, you are leaving in the total trust of the trustee, okay? So you're giving them complete discretion over that money. They're going to be the ones who are going to pay you income. You can get income from the trust. You cannot touch the principal ever again. If you do, it is no longer an irrevocable trust. So it's lost its asset protection strategy right there. You really have to trust the person that you name as trustee because they have total control of the principal of that trust and all the assets, whatever you put in it. You're not supposed to access it. So I'm sorry, I feel like I'm repeating it, but it's like, it's something that you really have to, I would just caution with. I mean, sometimes it's an appropriate tool, but there are issues surrounding it that you have to be aware of. And then the other thing is that it is subject to the 5-year look back. So if you're thinking you're going to need care or qualify for the Medicaid long-term care, then, and you think you might need it in 2 years, well, it doesn't make sense to do the trust because it is subject to the 5-year look back. So if it's the year 2000 now, I would say it would have had to be done prior to October of 2015. That's one way to look at it. Now, related to this question was whether it was needed to protect your home. And I would say not necessarily. So there are other ways to protect your home besides a trust, and it really depends on your situation. So when you apply for Medicaid long-term care, on the application, whether you're single or married, you can indicate on the application your intent to return home. As long as you check that box, your house is off the table. You do not have to sell it. You don't have to liquidate. You don't have to use it towards your care. And part of the reason is because for some people, you don't know if you're going to return home. You might. And the government wants you to have a home to go back to, as opposed to maybe coming out of nursing home care and then having to rely on further government benefits in order to live day to day. So there is sort of a policy consideration there in allowing you to keep your home. Now, oftentimes we have clients come to us and they've been given the advice from the nursing home, which I would strongly urge, never listen to the advice of the nursing home when it comes to your assets. Okay, please consult an attorney. Because oftentimes they tell, even if it's a married couple, they tell me you have to sell your house. You have to spend all your money before you can qualify and get down to the 2,500 and the 128. But it's simply not true. If you intend to return home, you can keep your home. Now, if you have a second property, okay, that's not your primary residence, you can actually hold on to that too if you're renting it. Okay, this is just one other possibility, another alternative. If you rent it, what happens is it becomes an income stream. And since there's income from the rental, you would have to pay the income over to the nursing facility as the applicant, but you get to keep the home. And there's an interest in the government for that too. They're okay with that, partly because on the person's death, they can attach a Medicaid lien to the home, okay? But they can only attach whatever they've spent on your care. They can't just attach some arbitrary number. If you had 3 months in the nursing home, then it's just 3 months of, it's 3 times the 9,231, okay? So there are other ways to protect your home. You don't have to necessarily put it in an irrevocable trust. And I would just say get really good legal advice before you head down the path of an irrevocable trust. Okay, so there were some estate questions too. One question was, how do I get paid for my mother's estate for caring for her during her life? Well, that depends. What does her will say? Does her will provide? Is there a provision in it that she wants like a certain amount of her assets to go to you because you provided care? You can't really reimburse yourself. The only thing you can reimburse yourself for is funeral expenses. So if your mother passes away and there's no money available and you have to use your own, then go ahead and use it. And when the estate is opened, assuming there's assets, you can reimburse yourself for the funeral expenses. But that's the only one that you can. Other than that, I would say, is there a written agreement made during her lifetime? I mean, if she's written an agreement, that might be something that, you know, when an estate is opened, you might be able to pursue. Okay, so dealing with the home. I think I may have answered this already. You can let it go through probate. It's not difficult in Maryland. You don't necessarily you don't have to put it in a trust. Then how to get online password account information when you're trying to administer an estate. Well, I mean, first you get appointed as personal representative. If you know the names of the banks, you can go and you get access. If you don't, then what we usually tell people is to just wait a few months, collect the mail, see what comes in the mail. You might be surprised, you know, there's gonna be bills, there's gonna be statements, and also check income tax returns for the last couple of years because you might be able to find out what accounts there are. The other thing when we're doing an estate plan for people is to encourage them to make a list. I mean, that's probably the best, that's the easiest thing for a family member who's going to be left administering your estate. Make a list of your accounts. You could put the last 4 digits of the account number. You don't have to put the whole thing if you don't want to. But it's great to have a list. Just attach it to your will of anything of value, safe deposit boxes, all the different accounts you have. You might have a TSP, you might have an IRA, you might have a checking, a savings, a money market. I mean, it is helpful for the family if they know that. There was a question about elder abuse laws in the state of Maryland. There is a physical elder abuse law. There is not a financial, but from what I've been told, there is one in the works now in the legislature. I'm not quite sure where it is at this point, but it is something that's been discussed. But in terms of financial exploitation, there are criminal laws. So those would be the ones that would apply. Okay, this was a really interesting question. I'm glad it was asked. What if a person dies intestate? So intestate means that you do not have a will. You've died without a will. Does a percentage of the assets go to the state? And the answer is no. A percentage, there is no percentage that goes to the state. What happens is the assets only go to the state if there is no one to take. So in the statute, there is a list of those who can inherit, and it's a fairly lengthy list. So there had to be no one to inherit, and then yes, the assets could go to the estate, but there's not a percentage. So this is always a great question, and I'm so glad that someone asked it. Why do I need a will? Right? Why? Make my benefit, you know, I've got kids, they're just going to inherit, or I'm married and my spouse is going to inherit. And I'm going to say that's not necessarily the case. So let's say it's a husband and wife. Okay, they don't have a lot of assets, right? They sort of have what a lot of us do: a house, some bank accounts, maybe a couple of cars, maybe a retirement account. So the first thing I would say is, in the state of Maryland, if there is no will, your money as husband does not necessarily pass right to your wife. She actually, by law, only gets 1/2. So that might come as a surprise to some people. So husband-wife, assets just don't automatically shift from one to another. Wife gets 1/2, and the surviving children get the other half, okay? And it's divided among the children. Children is children naturally born to the deceased and those who are adopted. Stepchildren are out. So if the deceased has a stepchild that they really love and they want to include, they're not going to be included. So I would say that is like the #1 reason to get a will as a married couple, is that you may unintentionally give half your assets to your children and you don't want to give it to them yet. You want your wife to have your assets or your husband to have your assets. So that is the #1 reason. The second is you get to choose your personal representative. So if you've got multiple children, maybe there's one child over another that you think is a little more organized and more capable of administering your estate. That means filing the necessary paperwork with the probate court. It's doing an accounting. It's distributing assets according to the will. It is paying claims by creditors. So there is an organizational component, and you get to choose who your personal representative is. If you don't have a will, there is a statutory preference of who should be personal representative, but people can start fighting about it. And so naming them in the will is one way to avoid that. Also in the will, you can indicate your funeral arrangements. If you haven't talked to anybody about it, that's a good place. They see where it is. Do you want burial? Do you want cremation? Do you want a big party? Do you not want a party? You can put it in there and everyone knows what your wishes are. It also identifies family members, which I think is really helpful. That can cause all kinds of issues. You never know, someone might show up out of the woodwork. So it's just good. It's another way to just kind of put everything very clearly. And then, of course, the big one, it clearly states what you want to happen with your assets. Maybe you want to divide them a certain way among children or nieces or nephews or grandchildren. That's the place you want to do it. The final question that I have here is also related to wills, is changing the beneficiary in a will. Do you have to change your will completely or add an addendum? So it's not an addendum, it's called a codicil. It's something that's very specifically drafted, and I would not attempt it on your own. You don't want to inadvertently invalidate your will. Also, don't try to cross anything out on your will or make changes. Again, you may inadvertently invalidate your will, and you don't want to do that. And some alternatives that I meant to mention in terms of, okay, maybe you really think you don't need a will, and once in a while, maybe you don't. Because, I say this very carefully, It really depends on your assets. If you have pay on death accounts, then you can name your beneficiaries. You can do percentages, split, divvy it up how you want. If that's all you have, if all you have are accounts with pay on death, then go for it. If you have nothing else, no stocks that are held in your name, because that's not pay on death. If you have a car, I actually have a form that's from the motor vehicles that I can somehow send out to you guys. You can actually fill out a transfer on death form with them, which is really helpful because once in a while we come across clients who they really don't need an estate opened. They don't need a probate case, but because there's a car, they have to, because it's the only way. So one way to avoid that is you can fill out this transfer on death form now. If all you've got a car and all you've got is a couple bank accounts, then maybe you don't need a will. But if you have a house, you have other assets that are titled in your name that don't have transfer on death or pay on death ability, then I would say you definitely need a will. And then one last little connection between pay on death accounts and your will. Pay on death accounts trump your will. Okay, they take precedence. If you have named Susie on your money market account as your beneficiary, the pay on death account, and you name Jody in your will to inherit everything, well, Susie's going to get paid from the pay on death account, and Jody's not going to get it. So the pay on death account beneficiary designations take precedence over whatever you say in the will. So that's just one last factor, and you'd want to make them consistent. So I'm open for more questions if there's more. I feel like I've covered a lot, so I'm sorry. I hope I haven't gone too fast.
Great, and we do have several questions from the chat. And so going back to the income for Medicaid waiver eligibility, in determining financial eligibility, is income defined as all monies? So does that include an IRA, Social Security, other types of income?
Generally, what we see is it's not our IRA or the minimum distributions. It's not that. It's going to be your pension and it's going to be your Social Security, basically. Yeah.
Okay. And the next question is coming back to the financial power of attorney. If you have no family members, what are the power of attorney alternatives?
And it doesn't have to be a family member, to be honest with you. It's anyone who you trust. If you have family members and you don't feel comfortable naming them as agent, you don't have to. You can name a family friend that's really trusted, a nephew, and we do have clients who name their attorney. So you can also name your attorney to act as your power of attorney.
Great. And this is coming back to the value of a home. How would someone determine the equity in their home? Do they need a professional appraisal or can they use a realtor's opinion?
That's a great question. I'm so glad it was brought up because I was thinking about it earlier. So we actually use the SDAT value, the Department of Taxation. So the state assessment value of your home is what we use. So when we do these Medicaid long-term care applications, that's what we print out. And that usually works in your favor. Because we sometimes have clients whose homes reach that upper limit of the equity, especially here in Annapolis, some of the homes that are on the water. And we use that SDAT value and it gets us where we need to be. So that is the value that is accepted and that's what we use.
Okay. Now coming back to irrevocable trusts, can you think of an example of when it is an appropriate tool? I know you mentioned to be very careful with this tool.
So I would say it's appropriate if if the person who's doing the trust is not anticipating long-term care in the next 5 years, that you have someone that you can designate as trustee that you know will take care of your finances and you have just complete trust in them. That you're comfortable in putting your money in this kind of trust and realizing that you do not have access to the principal, that you can be paid income from it. So if you put like a $500,000, cash amount inside of this trust, right? It's held in a bank account that's titled to the trust. And the trustee is going to pay you an income of, let's say, $5,000 a month. I'm just using arbitrary numbers. then fine. If you're comfortable with that situation, then it works. But you have to just have total comfort knowing that another person is going to be in charge of your money and is the trustee, and you no longer have access to it. So that would be my advice, that you're just very comfortable with that, you're comfortable with who you choose, and that you're 5 or more years away from long-term care.
The next question is coming back to the Medicaid lien. Does that lien on a person's assets or home happen in all cases for repayment of care after their death?
So that's a great question because the recoveries unit of the Department of Health is not always good about attaching the lien. So I cannot say that they're going to forget it in your instance, but we have had clients where they began as our client going into long-term care. We help qualify them. We help preserve some of their assets. They pass away. Their family comes back to us. We open a probate estate. It's open for 6 months. Creditors have 6 months from the date of death to file a claim. And if they're outside of that 6 months, then it's done. And sometimes the Department of Health does not come around. So it does happen. I can't say how often, but we have seen it happen.
Another house question. Can you put someone on your house deed while you're living to make transfer after death easy? I'm assuming in a similar way to the car title you were just speaking about.
Yeah. I mean, sure, you can do that. If we're talking outside of the Medicaid long-term care context, which is a little different, I would advise you to just talk to an attorney before you add someone to the deed or make any transfers. Because like I said, the home can be preserved and you might trigger something that you don't intend. So outside of that context, qualifying for Medicaid long-term care, of course, you can change your deed. You can add someone on it. You can add your daughter. You guys can be joint tenants, one with a right of survivorship. And so that way on your death, it passes to your daughter. But then you made her a co-owner. And then there is, I'm not great with this, but there is like the stepped up basis issue and whether there's capital gains tax if the daughter then sells it. So her tax implications are better if she just inherits it, if that makes sense. But if you add her to the deed while you're alive, then there may be a capital gains issue. If she sells it after she's inherited it, I mean it's passed to her and you've died. So that's a consideration.
Thank you. Now coming back to wills, can you write your own will? Is that legal if you've had 2 people witness it?
Yes. Yeah, you can.
Is it a good idea?
That's a good follow-up question. I don't know. It depends on probably not, to be honest with you. But I mean, if you've got no other alternative and that's what you need to do, then something is better than nothing. But the thing is, you may not capture everything and you may say something that you didn't really, you thought it meant one thing, but it means another. So it's just better to, I think consult with somebody. And to sort of tag along with that, like I said, I feel like the best thing you can do is get the whole estate plan. Okay, it's not just the will, it's the power of attorney. So the will deals with what to do when the person dies. That's one way to look at it. The power of attorney and the healthcare directive are dealing with the person when they are still alive, okay? So the power of attorney for finances is really, really important. A well-crafted power of attorney goes a long way. And it's so key because so often what we see happen is that someone becomes incapacitated or they have the cognitive ability, but they're so sick that they can't manage their finances. And that document is key. And the healthcare directive too, I think it's a great document to put in place. So you have stated somewhere clearly what you want to happen to you in certain based on certain medical conditions, okay? And you've appointed an agent so there's no confusion about who you want to make those decisions. You still retain power of your life, your finances, and your health. These documents are there in case you lose capacity or you're just unable to take care of those issues. So I would say consult an attorney, get all 3 done, and it's done and it's done right, and you have peace of mind and you've made things easier for your family.
All right, I think we're down to just 3 more questions, and this is a
Okay.
follow-up to what you were just speaking about. Do you need to have an attorney write up a caregiver's plan if a daughter or son is providing care for the parent?
Oh, that's a really interesting question. So, I think it depends on what context you're talking about. I'm not sure what the purpose of the plan would be because they come in different scenarios. So if you want to write up a caregiver plan in order to reimburse yourself for care that you've helped provide a family member, and if you're doing that for the purpose of preserving assets because the parent is facing long-term care, I would say do not do it yourself. Talk to an attorney. So that is an agreement that we do. And maybe, would it be helpful to give an example? I mean, I could, like, we do these from time to time. And again, it's very client specific. Okay, so it may not work in your situation. But we had a client who came to consult us because her father never got a power of attorney and he was in nursing home care. And she got to a point where she was able to sort of like do quite a bit, but she couldn't talk with his pension. They wouldn't talk to him. And she needed to like sign some documents so he kept receiving his income. And there were a couple of other matters. And so in the course of talking to this client, I said, well, okay, how much money is left in your father's name? Because you think you're going to have to apply for benefits soon. Well, there's about $21,000. And I said, I know you've hired us for this other thing, but we can like transfer that money and it could be a permissible transfer. Okay, so that way your father doesn't have to get spent down all the way to the $2,500. So what we wound up doing was this type of agreement based on the care she had provided to him in the past couple of years. It is a very specifically worded document, and I can't stress that enough. It cites certain laws related to Medicaid, and it has to have certain language that when the Department of Health reviews it, they recognize as this kind of agreement, and they accept it. But we were able to do that, and they are routinely accepted when we do it. And it can be done after the fact. Okay, the transfer can be done first. In her case, it was $21,000, and the agreement was written after the fact. So, and that's okay. But again, please do not attempt it yourself. Call an elder law attorney to do it, and someone who is like well versed in it, who has done it on a routine basis. Because we had another client recently who came. Her attorney was very good at foreclosure defense and helped her because her mother's home was going in foreclosure. He did a great job, but he tried diving into this caregiver agreement area, and she brought it to me, and I'm glad that he finally said to her, I don't know if this is going to work, go consult. And I'm so glad because she showed it to me, and I'm like, nope, this is not going to work. It's like, it has to be very different than this. I mean, he was on the right track, but it didn't have some of the specific language. So, and in her case, what wound up happening was her mother's house went into foreclosure. It went to foreclosure sale, and there's a surplus, which happens on occasion. So there was more money received from the bank than what was owed. And it was about $60,000. And we were able to transfer that money to the daughter. And mom still qualified for benefits. And it was done pursuant to this specific. It depends on the client and what's happened. So I hope that answers that question. That's a little tricky one to answer.
And then we do have a couple of more questions that have come in, but as a follow-up to this, in terms of the caregiving, if a family member is receiving pay for giving care to the parent, does that family member need to pay taxes on that income?
Probably, yes, it's income. Whether you report it or not is up to you. But I mean, it's probably considered income.
Okay, and so moving to just a couple of more general questions. If you're living with your parents, how would you know if they have life insurance? Do you have any practical ideas on that?
If you're living with them, just check what comes in the mail. You don't have to open I'm not saying open their mail, but you can see what's the return address. I mean, if something's coming from AARP or MetLife, I mean, it's possible. I think a frank and open discussion would be far more helpful. But I know that could be tricky.
In terms of working with an attorney, how much does it cost to invest in the services? at your firm or at a similar firm, an initial consultation or maybe an annual checkup?
That's going to depend. So it depends on what you're looking for. I would say generally speaking, we charge just for a consultation about $450. Okay. But we spend up to 2 hours with people. We don't rush anyone out the door. So if your story takes an hour, fine. And if it takes 2 hours, that's fine too. And we work through everything. And you get a lot of information when you're here. So it depends on what the services are.
All right, and I think this is going to be our final question today, but somebody asked that this all sounds very state specific. If you're dealing with relatives who are in other states that you may be caring for someday, either parents or siblings, are there ways to find this information on a state-by-state basis, or is the Medicaid and Medicare system fairly universal state to state? Is there a national resource available?
That is a great question. It is very state specific. Each state is different. What we do here in Maryland in terms of trying to preserve assets when someone's trying to qualify, how we turn assets into income streams so that way they're off the table, that's really going to vary from state to state. For example, in Maryland, if you have an IRA, if the applicant has an IRA, it has to be liquidated. And it has to be used towards their care, or we liquidate it and we put it in a different asset structure so it becomes unavailable. But in DC, from what I understand, IRAs are unavailable. The applicant doesn't have to do that. So, which is kind of helpful to know, because if that's like your main asset and you have a family member facing long-term care, you might consider having them go to a long-term care in DC for that reason. So it is very state specific. And there is no easy way to look this up online. And I'm just being really honest, just try Googling it. I mean, you're gonna get nowhere pretty quick. It's just, it's kind of complicated. There's no one place where you're gonna find, you know, like how, I mean, you'll find things about like how much money could be in your name and what are some of the income and asset limits. If you find that, you're even lucky. But getting like a lot of the technical details, you know, how can you preserve some of your assets? It's kind of an abyss, the internet. You're not really going to find anything. So if you have a family member in another state, what I would do is I would urge you to look on the NAELA website. It's all uppercase NAELA, like National Association of Elder Law Attorneys. It's a good resource. And usually the attorneys who belong to NAELA tend to be really top notch because they keep up with like current trends in their states, and you can find an attorney that way.
I'm just adding that in the chat.
Okay, and I'm happy, I can follow up and email you, Lee, with some of these things, and if you want to disperse it to the group, you can.
That would be wonderful. Well, I think that's it for the questions. And I thank everybody for their time. And I especially thank you for your time and your expertise. We really appreciate that.
I hope it was informative and folks learned some things. And really, I don't mind if you want to shoot me an email and follow up. I'm happy to talk to you, or you can call me at the office.
Great. Well, thank you so much, everybody. And everybody enjoy the rest of your weekend.
I want to say,
everyone.
Yeah, Jennifer, this was so informative. Thank you so much. And as
Thank you.
I'm Loretta, and I'm the chairperson of Helping Hands University Park, and we were a co-sponsor of this with Hyattsville Aging in Place. And our two villages are planning a part 2 to this. So everything that you learned today, there is still more, and maybe you'll have some questions that come up. So we hope to have another elder law attorney speak to us in January, on January 30th. So Jennifer, we thank you so much. I thought I already had a fair understanding of this, but wow, there is just so much. It's incredible.
I know.
It's really
I hope I summarized it okay. It is. It's a lot. It's a lot to take in.
Your presentation was excellent.
Okay,
and
great.
Thank you for recording it so that we will be putting it online. And it will be on our 2 websites, Helping Hands and HAP. So check in a few days and you should find it.
Okay, great. Thank you.
And Jennifer,